The courtroom was already leaning toward a foregone conclusion. Marlene Voss sat at the front table in a glowing dark pink blazer, her curly golden hair pinned neatly as if she were attending a ceremony rather than a hearing. Her attorney's paperwork was stacked with tabs and seals, arranged like a trap that would close with one signature. A sheriff stood near the aisle with police markings visible, expression unreadable. Then the side door opened and the air changed. Grant Holloway entered in a crisp white shirt and navy tie, carrying a county judge's black robe folded over his arm. The whispers cut off mid-breath. Marlene's certainty didn't fade slowly, it snapped. She had built this case around the idea that Grant would never show up. Instead, he arrived looking like the system itself had walked into the room, and her quiet victory suddenly had witnesses. Grant lived at Ashford House, a century-old stone home set on nearly 4 acres that had existed long before the gates of Blackridge Estates went up. The property's boundaries were clean and separate, recorded in the county plat map, backed by an exemption that kept the HOA's authority on the other side of a line drawn decades earlier. Grant wasn't flashy about it. He simply kept the certified documents locked away because most people never needed to prove what was already true. Then Marlene Voss rose to HOA president with a vision that required land, private clubhouse expansion, prestige amenities, and a connector parcel that Ashford House happened to occupy perfectly. She began with small demands designed to establish dominance: paint rules, fence complaints, parking restrictions, house number requirements, and road fees tied to a private lane Grant didn't even use. Grant responded the same way every time: calm, documented, unbothered. He didn't argue to win attention. He corrected the record and went back to life. That steadiness wasn't what protected him. It was what provoked her. The first strike arrived disguised as a bill, specific enough to sound official and large enough to scare. Grant opened an envelope and found a demand for $38,600 in unpaid membership fees, supposedly accumulated over years he had never belonged to the HOA. The figure wasn't random. It was engineered, high enough to imply delinquency, precise enough to feel verified. Grant requested proof of membership. What came back wasn't proof, it was a blurred photocopy of a contract that claimed he had signed into the association. The signature resembled his name but not his hand. A notary seal sat beside it like a stamp meant to end the conversation. Grant didn't erupt, because outrage was fuel for people who relied on intimidation. He went quiet and methodical. He checked the signing date and matched it against his travel records. The contract placed him in Blackridge on a day he was in another state entirely. That was the moment the dispute stopped being an HOA annoyance and became something uglier, a fabricated paper trail designed to take a home. Marlene and her attorney, Blaine Rutledge, didn't file a straightforward claim that could be challenged openly. They filed a quiet title action built for silence and speed, a default judgment strategy that only worked if Grant never stood in the courtroom. The court record soon reflected proper notice, but Grant received nothing. A sworn statement claimed he had been served and refused delivery, turning his absence into alleged defiance. Papers were dropped at the wrong address. A mailbox not connected to him appeared in the record as if it were his. Meanwhile, HOA mailers circulated through Blackridge, framing Grant as a stubborn homeowner refusing to pay, turning neighbors into a chorus without letting them see the facts. Behind the scenes, Marlene prepared for possession as if the ruling were already hers: lock estimates, signage drafts, and a developer visit that lingered just long enough to feel like planning. Grant went to the courthouse to inspect the file in person. What he saw wasn't sloppy, it was coordinated: altered parcel numbers, swapped pages, and a timeline that didn't align with the HOA's legal formation. The hearing was days away, and the machinery was built to take Ashford House before Grant could object. The breaking point hit when the land record system showed a deed transfer draft sitting in queue, waiting only for a judge's signature. This was no longer about collecting money. It was about changing ownership on paper and forcing reality to follow. Grant filed opposition immediately, but he understood how procedural theft worked. Once a default judgment existed, undoing it could take months, and months were exactly what demolition schedules required. He requested that the courthouse preserve every original filing exactly as submitted, because fraud thrived on revised copies and lost originals. Grant also disclosed a conflict. He was in the final stage of being sworn in as a county judge, and he formally withdrew from any judicial role connected to the matter. That withdrawal forced an outside judge to take the hearing and removed any excuse that the outcome was influenced. Grant kept his pending title quiet, not for theatrics, but because Marlene would shred evidence the instant she realized she'd targeted someone trained to detect property fraud. The night before the hearing, Marlene celebrated at the clubhouse like a winner. Grant spent the same night preparing what she didn't plan for, exposure that could not be retracted once it hit open court. The hearing opened with Marlene's documents stacked like a victory speech: the membership contract, the debt ledger, the service proof, the board minutes, the proposed order transferring ownership. Then the presiding judge paused on a detail so small it looked harmless, until it wasn't. 3 separate filings carried the same notary seal number despite different dates. Blaine tried to glide past it. Grant let the forged contract enter the record without drama, because lies preserved in official filings become leverage when the truth arrives. The timeline snapped next. The contract date predated the HOA's legal formation. The notary certification date post-dated the alleged signing. Grant's travel records placed him hundreds of miles away. The HOA's map shifted the boundary to swallow Ashford House, but it misplaced a natural creek, an error no honest survey could explain. The room's mood changed from routine to alert. Marlene's expression stayed fierce, but it now carried the unmistakable strain of a plan failing in real time. When the service affidavit was compared to verified location data, the case stopped resembling unpaid dues and started resembling attempted theft dressed as procedure. The court denied the default judgment and ordered the record preserved for investigation, because the pattern wasn't one mistake, it was construction. The lien claims were treated as void pending review, and Ashford House's exemption documents were entered with certified county verification. News traveled fast through Blackridge when residents realized their HOA dues had funded the legal push and that protecting property values had been used as cover for a private development deal. The board fractured under scrutiny. Marlene was removed as president, and an independent auditor was appointed to trace money tied to the clubhouse expansion. Blaine's filings were reviewed for verification failures, and the process server misconduct triggered separate consequences. The developer withdrew once the property's jurisdiction and title were confirmed, and the project that motivated the scheme collapsed under sunlight. Grant did not seize the HOA or chase spectacle. He returned to Ashford House and reinforced what had always been true: recorded boundaries mattered more than anyone's ambition. The community rewrote enforcement rules to require verified notice, transparent votes for major spending, and an appeal process that couldn't be bypassed by paperwork games. Ashford House remained standing, stone fence intact, front door unchanged, quiet proof that history could outlast a power trip. And the question that lingers is one viewers never forget: if a confident liar can weaponize paperwork, how many homeowners lose everything before they learn to document every single step?